We're now live. Thank you for joining us today for our Discipline Matrix Ad Hoc Committee meeting. The time is 6:02. We have our chair, Ricardo Garcia Acosta, who is in transit. We have our Captain Brian Hubbard, and we have Deacon Reginald Lyles. Let me see if there's anyone else in the audience that we should acknowledge. We have one participant from the public, Ms. Risa, welcome. And we're going to get started. I'm going to turn it over to Captain Hubbard.
All right, thank you. Hello, everyone. We're going to start with, we left off last week talking about custody of prisoners, and I'm sure that will take up most of our time this evening, but I do want to go back to 38470. If you can see my screen here, subversive organizations. I made some changes to it. I'll read it again. No member employee shall knowingly join, affiliate with, or support any organization, group, or gang involved in illegal activities or designated as subversive by a competent authority within the Oakland Police Department, including the Chief of Police, CPRA, or an authorized designee. Such groups include, but are not limited to, organizations that seek to undermine, disrupt, or overthrow any form of lawful authority, whether that authority be vested in federal, state, or municipal governments, city councils, or other recognized local governing bodies, or laws and regulations legitimately established under the jurisdictions of California, the United States, or other lawfully constituted entities. Additionally, any organization engaging in illegal acts against public order and safety may be considered subversive. The designation of a subversive organization will be based on a preponderance of evidence demonstrating that the organization actively participates in activities intended to undermine, disrupt, or overthrow such lawful authority or commit illegal acts against the public welfare. Membership or affiliation for any purpose related to advancing lawful objectives is strictly prohibited, except when such involvement is essential for official duties, supported by a lawful investigative purpose, and authorized in writing by the chief of police or a designated official. A long one there. The main change here is right in the middle. It was requested last week that we expand on what lawful authority is. That one is subversive against, and included federal, state, municipal, city, local laws, California, United States, etc. And as I stated last week, California Post, you'll see it here on the side, they have government codes that govern them. It doesn't explicitly address affiliations with subversive organizations, but it does talk about being in good moral standing. So one assumably would not be hired if they're part of a subversive organization, because that would not be considered in good standing. Questions on that section?
Excellent. I definitely appreciate the hack at this. This was pretty layered. The one thing that's kind of standing up to me is the area in the first paragraph at the end, the bolded area where it says designated as submersive by competent authority within the Oakland Police Department. Can we also, the way it's written right there, I have no problem with that, but in terms of law enforcement, can we also expand it to like any other kind of like law enforcement, folks that are knowledgeable, whether it be like an FBI or federal agent? I mean, there might be like a submersive gang that's in a database with the FBI that's been located, but maybe OPD doesn't have it on their radar yet or something,
Sure.
Yeah. I mean, that would be the only thing I would add on that, but I like that. That looks pretty good.
But that probably won't be my final. I'll write that better. Other law enforcement entities to include, maybe. Okay.
Like, DOJ, that type of stuff, right?
Yeah. Okay. All right.
Well, if an organization decided to have a march and demonstrate against, let's say, the Oakland Police Department for what they thought was some unfair practice or some decision made by some court or whatever. And they marched in the streets. Let's say like it was the NAACP. That would be a legal act, marching in the street. Could they be considered subversive?
What is their, I think if it's not illegal against public order or safety, I would say no.
Well, you know, every demonstration that happened in the past was an illegal act. Every one of them. Either they had them trespassing or they didn't have a permit to march in the street or not. So what they were doing was illegal. There's no question about that.
Mhm.
And so, you know, some of us may be so young that we don't remember those days, that we think we take for granted that someone or a group exercising their free speech and demonstrated. I just don't want them to be considered as being subversive. See, I thought the Subversive Act was not against overthrow lawful authorities. I thought being subversive was overthrowing governments in cities, municipalities. I think you ought to have a right to be able to demonstrate against the police. If the police have done anything, as long as it's peaceful, and you ought to be able to come out in the street and protest for whatever reason you want to protest. But if you're out protesting, and then now we say, hey, you're a subversive organization. I thought subversive means overthrowing a government. And it seems like it's blended here in my reading of it is, just being disruptive against a lawful authority. Well, as a police officer, I'm a lawful authority. And people have a right to demonstrate against the police. Or maybe you think they don't.
So it appears that we're hung up on seek to undermine or disrupt. If it just says overthrow, is that?
Yeah, I think you ought to be able to disrupt. I think that's free speech. I think that's First Amendment stuff. And but I'm not trying to overthrow the government. I just think that the police are acting in a way that I wish they did not act. But I don't want to destroy the government. I'm not subversive. I'm a citizen exercising my First Amendment rights.
I don't think there's a disagreement on the citizen side. I think this speaks to membership, like the officer. So do we want officers doing that?
And if I'm hearing correctly,
If,
it's also,
okay, go ahead. Go ahead.
no, go ahead. No, you go ahead. Go ahead.
Okay, yeah.
Captain.
An officer, an Oakland police officer, right, who's off duty and demonstrated against a agency in Modesto that did something that was untoward. Can we now say that this officer is subversive? I don't think he is. And I think he has a right to demonstrate if he's protesting against against spilling of oil in the bay, or environmental issues, or fresh air. Are you saying that if an officer does any of those things, they're subversive? I don't think they're subversive. I think they're demonstrating, and I think they have a right to do that under the First Amendment. And so I think disrupting goes a little too far.
Yeah. So Oh, I'm sorry, go ahead.
That's my, I'm done.
Okay. Yeah, and along those same lines, I also agree with you. Like, where does, like, a slippery slope, like, where do we draw the line, or where do you go from, like, exercising free speech or the right to gather legally, right, to now you're becoming submersive. Now you're disrupting public order, right? I mean, what if you're at a peaceful protest and now folks end up breaking property and disrupting the bridge and shutting down the street? Now they're doing illegal activity. Could that be interpreted as now you're being submersive to, like, government order and law, right?
I don't think you're being, I think it's
I don't
wrong
think so, right?
to deem a police officer off duty exercising his First Amendment rights. And for that person to be deemed subversive. I thought this subversive would be being part of a group, you know, a criminal enterprise, you know, some gang that is making, you know, illegal activity, or some group that wants to overthrow the government.
Yeah.
Or overthrow law enforcement. I have a problem with that.
Yeah, like January 6th.
Like January 6th. Thank you very much. That
At what point, Captain Hubbard, just kind of on a side note, just I'm trying to just process some stuff. If a cop is just out exercising their free speech, you know, the example Deacon Lau said, like, let's say like an oil spill in the Bay, and there's like a group that's protesting a oil company, or, you know, it has nothing to do with like law enforcement issues or anything like that, right? And they're out there exercising their free speech. And then at some point, let's say, and again, I'm not suggesting that this is submersive, but just on a side note, in terms of just like illegal behavior, like let's say a group starts splintering off, breaking property, disrupting traffic, doing things that are basically, could be classified as, you know, you get cited for or arrested for, right? At what point, I'm not suggesting that it's submersive, but at what point is an officer like, okay, maybe I need to walk away from this situation, because if I get photographed next to a person breaking glass, and they identify me as OPD, this could now be a negative reflection or bring ill repute to the organization. Like, is there a point now that you have a responsibility as an officer that, like, if there's laws being broken around you, that you kind of like step away from that, so that there's not a perception that you're a part of that? How does that work? Just aside from the submersive issue, just on a side note, how does that work?
Yeah, I mean, we have an obedience to laws section, and if you're the evidence will have to support your involvement in this, but the initial allegation would be obedience to laws, where you were there, you were participating in what then turned into illegal behavior, and the officer can be charged with that. If, to take it further, that group is considered subversive by, let's say, a competent authority, but moreover, preponderance of evidence that they're trying to overthrow something, undermine it to where it collapses, if you will, then the added charge would be subversive organization. Sure.
Gotcha. Okay. So there is a lower level of just being around illegal behavior, and that's not necessarily with this clause. This right here, 38471, is really around submersive, like the intent to like I would think it's more around seeking or the intent to actually subvert an established system or institution or government, you know?
Yeah.
And that's what this is what it's speaking towards, right? I just want to make sure, to Deacon Lau's point, that we're not creating something that's meant for that, and then it ends up impacting people's free speech, you know, and right to assemble and things like that.
Well, again, here it says to undermine or disrupt a lawful authority. And disagreeing with a police officer is not subversive. Or disagreeing with a police agency is not subversive. Overthrowing the city government is subversive. Planting dynamite, disrupting the government process, you know, that could be deemed as subversive. But disagreeing with a police officer is not subversive. I don't have to agree with a lawful authority. even when I'm wrong. I'm innocent to proven guilty. So I just think that the way a law, undermine, disrupt, overthrow any form of lawful authority. No, police officers can be disagreed with. We can
You're saying
disagree
that's
with
too
the
much of a
police
slippery
department.
slope, then, is what I'm hearing.
I'm sorry?
It's too much of a slippery slope, is what I'm hearing then, because
Well,
anything could get interpreted as
No,
that.
I want to be hardcore on this. Police officers are not governments. They're not always right. Then they are agent of the government. Disagreeing with a police officer, you have a right to do that as a citizen. The police and the government has to prove me guilty. I'm innocent, and I have a right to protest and say, no, I'm innocent. I have a right to do that. And so now, if you have it written in here, this could be interpreted that, well, I'm a lawful authority. You disagreeing, you're disrupting a lawful authority. Well, we got enough laws on the books to deal with that, 148 and all of that. You can use 148 PC. You don't have to have this in here teaching folks that anybody who disagrees with you, is subversive. They're not subversive. They're innocent until proven guilty. It just indicates to me how far we've come in this country. And it's scary to me. How far we've degraded from my political perspective. Police officers are not absolute. They're not governments. They're agents of the government, but they are lawful authorities, and we can disagree with them. I can say, no, I am innocent. Now, if I fight with them in terms of an arrest or anything like that, you got 148 PC. You don't need this. You don't need or overthrow any form of lawful authority. You don't need that.
You're saying that part, remove that out, because then that opens it up.
Because a police officer is a lawful authority, and he's a form of a lawful authority. So you equating an individual police officer on the same level with a government. And overthrowing a government is subversive. Disagreeing with a police officer is not subversive. It's right now it is. You're part of your Bill of Rights. It may change in a very near future, but right now it's a part of the Bill of Rights, the Fourth Amendment. You're innocent to proven guilty. I can disagree with your lawful authority. So I think this is dangerous, because people read that and it may encourage them to do things that they shouldn't do.
Sorry, I want to make sure I understand this. So are we challenging the undermining and disrupting, or the lower level?
We're challenging undermining and disrupting or overthrowing any form of lawful authority. A part of lawful authority is a local police officer, right? So you're saying I can't disagree with this. I can't disrupt this officer. I can't say, no, I'm innocent. I can't do that. Now you're saying, well, no, we're only talking about police officers. We're not talking about a citizen. Well, I can't take a police officer out of this. A police officer is a citizen, and they may be living in their community in San Francisco, but working in Oakland or Modesto, and they're protesting something. They have a right to do that.
Yeah, I agree. How can we work? Can we say like government institution or government system, something like that, so it's specific to
Government.
overthrow systems and institutions, not like you're saying on an individual level, and then that get interpreted as like, oh, well, now you're just being submersive to all of our authority because you won't listen, or whatever that might be, right?
Yeah, and the individual police officer hasn't lost any authority. He still has 148 PC. You interfere with a police officer investigation, he still has all of that. Use that. Yeah. But this is going to, what does this teach folks? That hey, we can charge them as being subversive.
Oxford Dictionary says submersive as an adjective is to subvert. Oh, yeah, an established system or institution. Seeking or intending to subvert an established system or institution.
Yeah, you're talking about citizens. You're talking about cities, municipalities, governments. You're not talking about individuals.
Good evening.
Good evening.
Well, we got a lawyer on the line, so I'm glad.
Chair, we have Risa raising her hand in the audience.
Excellent. Is there a way to have her come off mute to be able to contribute?
Yes, give me a sec. All right. You're muted, Ms. Risa.
Thank you very much. To Deacon Lyle's point also, I'm also concerned about any organization engaging in illegal acts against public order and safety, that any organization, as a Jewish person who has been protesting in support of Palestinian rights and have been called anti-Semitic, I'm concerned about how broadly this is, because there are laws that are either in process of being put in place or have been put in place that say I can't legally boycott Israel. And so I'm concerned about how broad things are, to Deacon Lyle's point about police officers being private citizens on their off time and what rights do they have.
Yeah, I totally agree, and I think the issue of Palestinian rights and objections over what's going on in the Middle East, I think that's a great example, and we've seen that. I mean, we've seen in Oakland, we've seen the Black Panthers free breakfast program get labeled one of the top public safety threats to America, right? And it's like, and if a cop was going out there and just feeding lunch, but because we had COINTELPRO, it was being deemed a subversive organization, right? I mean, it is a slippery slope, and I like that idea. I mean, I think a police officer should have the right to either join a pro or anti-Israel protest, or pro-Palestine or pro-Israel protest, either way, and be able to express their free speech without being labeled a terrorist or something like that, right? But I think where it gets tough, and help me out, folks, is if you have an organization, let's say there is a known organization that's advocating for human rights one way or another for some political issue, like some unnamed political issue, and there's a segment of that population that is doing stuff that could be deemed as domestic terrorism or things like that, right? How at some point it is a responsibility of a cop. I mean, I guess it's a very fine line of like, well, as a private citizen, I have my freedom of speech and could exercise my right to express my political views. But then if I start aligning myself with an organization that's known to have done some either violence or other type of stuff, then I just think the opposite. Like, I don't know, I would think that OPD would be advised to stay a little bit away from that, just the opposite. But if somebody was like, no, I need to go there, does that make it illegal, or are they violating laws by doing that? I don't know. It's a tough one. And then really, if you really want to get deep about it, Captain, too, right? If you look at the January 6th, and you look at even our own Department of Justice, and folks have been convicted of being subversive and trying to, participate in acts to overthrow the government. Well, now we have a new president and we're gonna have a new DOJ, and they're actually gonna flip it and say that these guys are patriots, and they want a submissive organization. So really, it all depends on the government classifying these groups and whether you're participating or not, and how your participation is at the point of when they're being classified. Just like J. Edgar Hoover, where to classify the Black Panther Free Breakfast Program as one of the biggest threats in America, right? On the flip side, now you got Donald Trump saying that the January 6th guys are patriots and they're going to be, they're going to be targeted. So I don't think our federal government is helping us out on this one. It's making it a little more complex as well.
You need to take out any form of lawful authority. We're only talking about governments. We're not talking about police officers.
And we have to remember the First Amendment does allow you to protest. So we have to be careful that seek to undermine, because Black Lives Matters, targeted as subversive, where MAGA isn't. So
Correct. Yeah, it just depends on whoever's making that determination.
correct.
Well, I think by removing any form of lawful authority helps move us in the right direction. At least it doesn't open it up with such a broad thing where if a cop, you're not listening to a cop's orders, you can't be labeled as being subversive.
And we got to keep in
To your
mind,
point,
if we bring up January 6th, they actually wanted to stop the counting
Transition.
of the votes. They were
That's
trying
right.
to overthrow the running of the government.
Right.
and to that point,
They were
guys,
subversive.
we had some Oakland police officers participating in that in that overthrow.
Yeah, that was an overthrow.
Yeah.
But-
So while we definitely want to protect the, right to free speech and all, there are some things that police officers should not be able to do. And I
Well,
believe that participation in something like January 6th is one of them.
And my point is that January 6th was subversive. It was the epitome of something subversive. They wanted to stop the counting of the votes of the Electoral College. So they were trying to stop it. That was subversive. But
you know what's interesting? It certainly was, but then you're going to get Trump, perhaps, once he's Trump in power, perhaps pardoning all of those.
yeah, but
people.
again, and I agree with you. I'm sensitive to that, but we're talking about here an officer being considered subversive if he or she participates in any protest that disrupts, I'm not saying overthrow, remember, disrupts, or so disrupts any form of lawful authority. That's too much. And so January 6th is not a good example because they were subversive. They actually did try to overthrow a government, the federal government's counting of the votes. That was subversive. But disagreeing with a police officer, even if you're another police officer, disagreeing with a police officer You have a right to do that. And he said, well, he's disruptive. How is he disruptive? He did not say he was there. He did not answer my question or whatever. I'm gonna arrest him. Well, fine. Or he resisted. Okay, 148. You got all the tools you need. You don't need this. You don't need to add any form, disrupt any form of lawful authority. That's too broad of a brush.
I tend to agree with you only because we have to be careful that we do not, just because you're a police officer, you have no First Amendment right. They may be curtailed a bit, but as long as it's not an unreasonable infringement on the First Amendment right. So we do have to look at this from the point of view of how we are impacting the officer's ability to do his or her job without aligning his or herself with subversive groups, but also have the right to exercise First Amendment rights. And, that's just going to be on a case-by-case basis. Okay, so have we beat this to death already?
Yeah, I'll take another crack at it for not next week, but a couple weeks from now.
Okay.
Okay, we then left off with custody of prisoners. So as we discussed last week, there's only a class 1 version of this, and the problem with this section is that the discipline range is counseling and training all the way to termination. And for those who couldn't join us last week, we had a discussion about the Freddie Gray type treatment that you saw in Baltimore, which was deemed intentional and inhumane.
Yeah.
And then
He
you
was
have
the one that was unrestrained in the back of a paddy wagon, right?
correct.
Yeah.
And then you have, let's say, an officer who's driving from Oakland all the way out to Dublin to take them to jail, and they have to use the restroom, but the officer really, intentionally is trying to facilitate that, but you're stuck in traffic at 3 p.m. heading out to Dublin. The restroom is not available, but you're doing your best. Those two examples are in the same section here. So to help combat this, came up with two different offenses, the class 1 versus class 2. This is many edits that I did between last week and what I sent last night. So my brain was fried by the end of it. So I hope tonight we can, similar to our previous discussion, edit this as needed. So the class 1 offense, inhumane treatment, refers to any deliberate or intentional act of neglect, abuse, or mistreatment toward a prisoner that violates established standard of care, resulting in serious harm or creating a substantial risk of harm. This includes denying access to restroom facilities, refusing necessary medical care, or engaging in physical, verbal, or psychological abuse. To ensure clarity, inhumane treatment excludes brief, context-dependent delays that arise from operational necessities, provided such delays are reasonable, documented, and promptly addressed. So that's the class 1 offense. And class 2, this is general neglect or procedural deficiency. General neglect or procedural deficiency involves non-deliberate lapses in prisoner care resulting from technical oversights, procedural mistakes, or minor compliance failures. These incidents lack malicious intent, but may still compromise prisoner welfare. To address varying levels of severity, the classification distinguishes between minor technical errors with minimal operational impact and significant procedural breakdowns that pose greater risks. Corrective measures will be proportionate to the severity, frequency, and resulting consequences of the failure. So maybe we could take small bites of this. Let's start with the class 1 offense. And really the theme behind this is just straight inhumane treatment. And I don't like to include too much of the word intentional, because one can then just walk in and say, well, it was unintentional. But you can see based on the evidence whether something was intentional. Like someone saying over and over they have to use the restroom, and the officer was in a position where they could take them to the restroom and deny them that would be, I would say, a class 1 offense versus the other example that I gave. Then the class 2, well, I won't even talk about class 2. Let's just stick to class 1. Is there anything that sticks out to you, or things that need to be fixed?
Yeah, the first thing that leaps at me is the word, maybe another word in between deliberate and intentional. I like those 2 words, but I would say deliberate, intentional, or callous act of neglect.
Yeah. Okay. Next. Okay.
So I think you were driving at the meanness. There's something mean in about this act of ignoring a person when you could take them to relieve themselves.
Right. I mean, there's some intentionality behind that, because I mean, I'm technically not intentionally doing it, but could I mean, could the reasonable standard is what we're using here. Is it reasonable for the officer to do X, Y, and Z? And if so, then they should do it. If not, then it's a class 1 offense.
Right. And I'm saying that deliberate, you can be deliberate and intentional and be within good police practice by not stopping for someone to relieve themselves. But if you're doing it deliberately and intentionally to be mean about it,
Yeah.
then, and if we can, and each case stands on its own, but we can prove that you were being mean, there was an opportunity for you to stop. There was no risk to your life or whatever. So that's why I said, or callous should be there.
Yeah. All right.
Otherwise, I think it's fine. I think
Well, Captain, we recently dealt with one of these things, and so and in that space, I would argue that it would have been very helpful for us as a commission to have a tool to be able to separate whether it was a class 1 or class 2 level violation in this. So yeah, I mean, I kind of like this because then we're not stuck into just one level of within the discipline matrix. It gives us some optionality depending on the egregious nature of the offense.
Any questions on the class 2 then offense?
yeah, it was a mistake. I didn't hear you. I guess I'm trying to think of examples in my mind how someone cannot be taken to use a restroom when asked. And only time I can think of it is like when it's not safe,
Yeah.
when it's not
And-
safe to the police or the public.
And an individual transport as opposed to several being transported at the same time. Perhaps. I'm trying to think of a scenario.
If you have 2 or 3 prisoners and one officer's doing the transport, I'm not taking anybody to the bathroom.
That's the scenario I was trying
Yeah,
to
that's what I thought too.
imagine.
Yeah,
Yeah.
I'm not doing that. Or if I'm transporting it's a flight risk. Even if it's 2 or 3 officers, I'm not taking anybody to the bathroom. Once we're en route.
Yeah. I mean, if I just arrested somebody for an attempted homicide and they're twice my size, I am not pulling over on the side of this freeway in the dark to let him use the bathroom, right? It's just, especially if I'm by myself. But I think one of the things we talked about too, Captain, is like, is there a need to put language in here, or is this more of a training thing where it's like, if you're in that position, in order to cover your ass so you don't get caught in violation of one of these offenses, you call it into a supervisor. You say, hey, this guy's requesting the bathroom. I don't feel safe. I'm on my way. I'm trying to get there as fast as possible. Because then that displays and shows that you're making a reasonable effort to accommodate their needs, and you're not being inhumane. You're empathizing with, damn, I shouldn't use the word. You're acknowledging them, right, in terms of what their requests are, but it's just not safe. And you're like declaring it for the record. It's not safe. And I'm covering my ass and I'm coming in as fast as I can. Because I don't want him to have the accident in my car either. Because I can imagine like cops don't want that in their cars either, right? I mean, so.
Yeah, great question. It would be more applicable to the policy, DGO 02, I believe, and then training to go with it on procedural, because we need something. If we're going to call like the class 2 offense more of a procedural deficiency, then we have to refer back to something which would then be that policy that says, if this, then you need to do this.
Gotcha.
Yeah.
So it sounds like that may need some updating too, then, to go
It
along.
does. It does. Yeah.
Especially if we're going to parse out class 1 and class 2 then, right?
Yeah. That policy is overall pretty old, and it doesn't really speak even to what we're talking about here. So it definitely needs to be updated. Like, for example, we shouldn't be in a position where one officer is transporting 3 people. I mean, the
Yeah.
department is setting them up for failure if that's the case. And even like the example of a homicide suspect, even with multiple officers, well, we do train to control someone with limited handcuffing, if you will, so they can use the restroom. So there's a balance between both of those.
And and this is not a common occurrence. It will always be that one incident when there's a crisis on the street. You don't have enough officers. You got to get these people out of here, and you could only spare one officer, but they're handcuffed.
Right.
So.
Yeah, the examples minus the one we experienced recently that I can't talk about is restroom. The restroom issue has been and still is a very difficult situation and the officers that have been caught up with this offense, one can argue it wasn't intentional. They just were paralyzed by unable to make a decision, because by them making a decision here, they would subsequently violate another policy, whether it be use of force or failure to take a complaint, etc. So there was kind of a ripple effect with their lack of decision on whether one should use the restroom, but it was categorized as inhumane treatment. Maybe we can give it a couple weeks and we'll come back with fresh eyes after the holidays and look at this again.
I think it looks good right now, but thank you for what you put done thus far.
Certainly.
Unless people have other objections or input, I mean, I guess we could chew on it a little bit longer, but it seems pretty straightforward to me.
I don't have a problem with it.
Yeah.
Right, okay. So we have an option here. It's 6:47. So we highlighted these last week. So another big one is use of force level 1 through 4. And then the other one is truthfulness. That's another section that we highlighted. And then finally, refusal to provide name or serial number. So are there any ones you want to get started now for discussion?
Well, let's do 19, 20, and let's just go in chronological order, I guess.
Okay. So this one is refusal to provide a name or serial number. And I'll just give you a little bit of context here and where what we talked about is possibly having a class 2 consideration. And I'll give you some examples of why this. So the heart of the NSA, one of the hearts of the NSA is officers who just flat out refuse to give their name and serial number. And we all know why one would do that is someone obviously wants to make a complaint against the officer and they want to stand in their way and prevent that from happening. And they do so by refusing. Refusing is a strong word that, and we do get those cases where it is a straight refusal. You're standing in front of me, you ask for my name or serial number or badge number, it's all in the same family. I flat out said, no, I'm not going to give it to you. Okay. That's a clear violation. It's a class 1 violation. Where we have run into problems though with that argument is when there's an officer, let's say, who maybe was there but didn't hear the person ask for their name and serial number. And then it becomes an argument over whether one should reasonably hear. And this usually comes in the form of a body-worn camera review. There's a chaotic scene. I'm the reviewing supervisor. I hear someone say, hey, give me your name and serial number, and the officer doesn't do it. Our mindset goes to this section. However, the officer will say in their interview, well, I mean, there was a lot of stress. I was dealing with this person, this person, this person. I honestly did not hear someone ask me for my name or serial number. Or another example where we run into problems with this is someone who's upset at the police and there's 10 officers on scene and they just kind of blurt out, I want your name or badge number or serial number. The question is like, who are they actually talking to? And I don't know if you heard this analogy before, but it's someone like the house is on fire and you assume that someone else is calling the fire department and then it turns out no one does. So sometimes we assume, okay, yeah, I heard it, but I thought this officer who was actually with the person did their job and provided name and serial number. So it gets a little bit more complicated as we saw. I have seen these examples throughout my career. So the conversation, if there's a possibility for us to create a class 2 consideration similar to the care of prisoner, where there's just a flat out intentional refusal, which one shall not ever do. But there's a class 2 consideration where there was a misunderstanding, maybe a language barrier, maybe it was just an assumption that someone else was doing it, but it's just a softer category. So as it reads now, I'll go ahead and read it. This is how it reads now in the manual of rules. Upon request, members and employees shall supply their names and serial numbers to any person who seeks such identification. That's it. And it carries a pretty hefty discipline to go with it. 398.77, excuse me, let me. Yeah, so it's the first offense is suspension 3, so 3-day suspension all the way to termination. The second offense is a 30-day suspension to termination. The final one is termination.
Pretty serious.
Yeah.
Yeah, they're supposed to have their badge number and name on their uniform, right? And it's supposed to be prominently printed on their shirts and on the badge number, right? And on their shoulders. Am I correct?
That you are correct, yes.
All right. So if someone says I didn't hear him, and we were in a chaotic situation and I didn't hear him, and that's one thing. But if I'm looking at the body worn camera and the guy is less than a foot from you, that's a different scenario.
Right.
So if the officer can prove, look, I didn't hear him. He was talking to me. I was on the ground wrestling with the suspect number 2. You know, if that's the case, I'll buy that. That's logical to me. But this 2 that you are suggesting, which I don't disagree with, if you're standing in front of somebody's face, you know, why didn't you hear him? That's my second question. You know, and if I'm standing with 4 officers and a citizen says, I want your badge and your phone number, excuse me. I want your badge number, your name and badge number. First thing I'm gonna say, you talking to me? So maybe we can write that in, that if someone is addressing an officer, it's the officer's obligation to find out that who the person is talking to. The citizen who's asking for the name and badge number doesn't have to get it right. I want to put the responsibility on the officer to inquire. Are you speaking to me? My name is Reginald Lyles. My badge number is 106. You know.
Right. And our policy is, when you can't just point to your name tag or your badge and say, hey, here it is. It needs to be an actual document that we provide.
Right. No, I get that. I don't want to use that as an excuse. I'm indicating that in achieving what the citizen is supposed to be after is aided by the name right there and the number. It so that an officer can be distracted, didn't hear him, but it has to be a genuine distraction. It can't be, you know, I just didn't want to hear him.
Selective hearing.
You know, my name was Lyles. He didn't say Lyles. He said, I thought he said Miles.
Yeah.
you know, we're not going for that okie doke.
Well, as it stands, it's currently a class 1 violation.
It is, and there's no class 2, right?
This seems something kind of along the lines of the custody of prisoners that we were just looking at. Like, there's got to be a distinction between, like, gross neglect versus, you know, an intentionally neglecting somebody, or intentionally not giving your name, versus like one of these scenarios where it was just like a procedural or an intentional mistake.
Right. Yeah. And to me, it's like this, you're intentionally undermining the negotiated settlement or our policy based on your behavior, versus we could have done things better. And the other thing is, if I'm giving someone a citation, that does not count. So I cannot say, well, my name and serial number or badge number is on the ticket. Here you go. Have a nice day.
Yeah.
It's even more, our policy and practice is even more intentional that if we accept what they're saying as displeasure towards us. So we give our name and serial number, but then the follow-up question is, would you like to speak to a supervisor? So there's really 2 sections here that we would use in that scenario. So the way I hear this is we have the gross misconduct where the evidence shows preponderance that you reasonably should have heard the person ask for this, and you failed to follow this, versus it could be that you didn't hear, or you didn't follow the other procedure of how it was provided to them, but it was not in that gross misconduct category. That's where we're going. I can, similar to one before, I can give you a couple options and see where that gets us.
I think it's pretty straightforward. I mean, except when it's like someone gave the example of there being several officers and someone asks for the badge number, but isn't specific with respect to which officer is being referred to, but also it might be just loud and chaotic and the officer doesn't hear it. So I don't know if we want to put any caveat at the end, except where circumstances prevent it. But that's just giving an out to make up a whole bunch of stuff that maybe we don't really need to deal with. I don't know. I think it's pretty straightforward.
When I think any language like that that identifies kind of the lower level, I think that's what Captain you're saying, right? You're going to try to take a hack at maybe coming up with some language that kind of identifies what a class 2 is, where it's more unintentional in that way, in that regard.
Unintentional, you could have done better. I mean, obviously there are going to be circumstances where even on body worn camera that's enhanced, we can come to the conclusion that there's nothing the officer could have done. The person whispered it in the back of the car. There's no way the officer could have heard that. I mean, that would be an exonerated finding. It's not that we have to have a finding for this, but I think we're saying that we just want a lesser form where you could have done better, but your intent was not to undermine or prevent that person from making a complaint against you, or, you provide your name or serial number. So I'll take a stab at it. I think I know what we're all saying.
Yeah. I mean, and the chances of it maybe not as common, but I think it would be, again, like in a disciplinary hearing or in a setting like that, it would be good to be able to weigh in on like, I'm looking at this and is this a level 1 or a level 2, right? And versus like, oh, this is only a level 1 as my only option. And then I have to like kind of grave it on the curve because it wasn't that egregious, right? And then bring it down below the scale options, right? And that just doesn't feel good either. So okay, great. I think we can do this. Yeah, I'm like envisioning like an office, somebody asking for their name and they're about to tell them like, oh yes, sir, my name is, and then a phone call comes or a gunshot rings out and then they totally forget to double back and provide that information. It's just like, I was going to, and I just totally forgot because something else happened, right? And it was unintentional. You saw they had an intent to do so, but then they just ultimately didn't, right? So, or actually in that scenario, Captain, would they be exonerated?
No. No.
Okay, good, because it's still on them. The onus is on them to still, at the most reasonable time after that's settled, to go back and still provide that.
Well, I mean, that's a point of contention also, is like, because right now it doesn't even say that. It's, we provide, now there's no time frame per se as you read this, but that is a consideration, and happens more often than you think, where someone says, give me your name and badge number. The officer is literally wrestling with the person to get handcuffs on them. The officer even will say in their interview, yes, I intended to do so. I just flat out forgot because, time has passed. So we don't expect officers to give it right then and there. But if they do technically forget, then they have violated this policy.
Right. Which to that point, I'd be like, oh, I think we're talking about maybe a class 2 in that scenario, right?
Right.
Considering all the circumstances. All right. Yeah.
Okay. All right, great. I will take a stab at that. Truthfulness 39880. This is a class 1, and there's nothing on the matrix for this except for termination. There's no range. It currently reads, members and employees are required to be truthful at all times. whether under oath or not, except when necessary in the performance of official duties. Such exceptions shall be documented on the appropriate police report. I believe looking through my notes, I wasn't part of that meeting because I was out of town, but someone brought up the question about juveniles and truthfulness. But I'm open for discussion.
If I remember, oh yeah, that was me. So I think what we wanted to look into is, I believe, and I don't know if it was last year or this year, but there is a new state, if I'm not mistaken, there is a new state law that does not allow officers to intentionally lie to juveniles under the course of an investigation, or if they're, questioning them.
Wow.
Whereas I think for adults, you all could kind of do that in questioning and investigation, right? Kind of.
Not kind of do it, they can do it.
They can do it, right?
Yeah,
You
it's
could gladly look
called
at
a
somebody
rule.
and be like, "Hey, you might as well tell me because your friend just told me everything."
It could be, you can, the officer can say anything. It's called a ruse. It's a lie, but it's it's a ruse. But you're saying that in the state of California, the law has changed where juveniles cannot be lied to, or
Ruses,
a ruse cannot be used in the interrogation or of a juvenile. I gotta look that up. I didn't know that.
Yeah, and I think those were the notes, Captain, is like we needed to look that up. Like we need to be sure about that, but there was just something there that we remembered, like, oh, I know there was a new law coming into effect, but we weren't clear on what that was, and if that had a direct impact on this.
Yeah, it's Assembly Bill 2644. It was passed this year, in March to be exact. And I think I have to look further into it, but I believe it's specific to interrogation. So this is where it can get a little bit technical, because one can say, well, they're not under arrest, therefore they're not being interrogated. Therefore, I can lie to them because it's not an interrogation.
That's right.
Yeah.
That's right.
Which makes sense.
You're out on the street and asking questions. That's an interview. It's not
Right.
an interrogation. So
that law is very specific to once an arrest has already been made and they're going into a formal interview process with that minor. But is there a line of delineation that, okay, now we're entering into interrogation area. This is no longer just, on the field trying to determine if I'm going to even arrest and make charges. Press hard.
Yeah, and then I have to look at the text of the law because it might be nuanced, because if the intent behind that is to get enough probable if you're at the reasonable suspicion standard where it's it can go either way, and you're doing that interview and then their statement kind of tips you over the edge, that's one argument, versus the de facto arrest category where I already know that I'm going to arrest them because I have enough probable cause, but I'm going to use a ruse to get them to tell me more. So I'm not placing them under arrest. I'm just acting kind of cool with them. And then boom, I launch an arrest on them once I get them to respond on my lies. So
Incriminate themselves, basically.
Yeah, it's called a de facto arrest, or even de facto interrogation for that matter, depending on how I question them.
Okay.
And if the language just says interrogation, then interviewing may be allowed. Someone can argue, look, I'm just asking questions. I'm not trying to impeach him. I'm not trying to catch him in a lie. I'm not trying to show that he's being disingenuous. I'm just saying, hey, what's your name? Where you live? Do you live over in the waterfront? That's not interrogating anyone. So we got to look at the language of that. AB 2644.
2644, yeah.
Okay.
And I don't even think they call it truthfulness. I think it's straight psychological tactics or something.
Yeah. Yeah, it probably is nuanced.
Is there any laws, Captain, around if a minor requests legal presence, at that point, they have to have an attorney to continue the interrogation? How does that? I know there's different things like that as it pertains to minors.
Yeah, so the law, that law got passed a few years ago also, where it's actually an automatic, it's regardless of whether they requested, it's an automatic phone call to the public defender for all juvenile arrests. So before even proceeding with an interrogation, you have to call the public defender. Yeah.
That's that Miranda 24-hour Miranda line that they have, right? I think it's what they
With
call it.
juveniles, you have to Mirandize. There's no like them really. It's so this is where we can, it gets a little weird because again, if you don't place them under arrest, there's no Miranda requirement. And so that's where you can kind of reverse engineer it.
Hmm.
Yeah, there's a lot of leeway in that situation.
Yeah.
Too much.
I mean, you can even take the language even further. It's like separate juveniles, just anyone who might not understand their rights.
Mm.
You need to stay away from playing games with this, where let's say there's a language barrier, or let's say that someone's just they're mental not capable. I mean, it's not even it's someone's intoxicated. You can take advantage of that. If so, all these different things have Miranda implications, and truthfulness can fall into that same category also. Like, is it easier for me to lie to someone when they're intoxicated? Maybe.
How does the DA feel about this? Like, if do they get to the point where they're like, well, you guys are, like, this case is no good. I can't prosecute this because you were manipulating this juvenile and he was under the influence, and it's just like, at some point that makes their case harder, right, in terms of prosecuting it.
Yeah, it's weird how I've experienced a DA also where they've been mad at me for not doing enough. Like, for instance, I used to teach laws of arrest and search and see in the academy, and so I was really conservative with this. I would don't play any games with Miranda. So I would teach people, hey, if someone's reasonably intoxicated, it would be very wise for you not to proceed with interrogation, because you're basically saying that they're unable to care for themselves. But then I had the DA call me one time and say, yeah, that's you're being way too conservative with that. Sometimes people, when they drink, they get loose lips, and you should let them talk. So I don't know. They sometimes are conservative, sometimes not so much.
Gotcha. You just made me think of another instance where I've really seen this kind of happen. With GSWs, with gunshot victims. And somebody's, strapped to a gurney in the trauma bay, heavily medicated, and then CID comes in and starts to get statements and starts to investigate it, like, and they're just like totally in a loop, don't know what they're saying. And I've seen that be quite problematic as well.
Mm.
Yeah. We do have a Miranda section that we will, I'm sure, get to. Truthfulness does have some overlap with that, but just taking what this is, truthful at all times. So I can tell you that where we run into problems with this, mistake of facts, as in, sometimes our investigations are months later from the incident, and we're asking an officer to remember what happened, and sometimes the facts just don't line up with what's on body-worn camera. But is it a truthfulness issue, or is it just time has passed, mistake of facts?
I can't even tell you what I ate for breakfast yesterday, Captain.
Right. Yeah.
It's tough.
Yeah.
So is the threshold to violate truthfulness like that? You have to really see like they intentionally are lying, or I mean, it's just hard to kind of determine that.
The way it's written, it doesn't have really the intention behind it. sometimes we also make the argument of whether the lie is supposed to benefit them, as in, is there a reason to lie? But this is a narrow threshold because we're only talking about preponderance, and one can easily say, well, your facts don't line up, you're therefore lying. Done. And you get terminated. But I'm certainly not suggesting that we make a class 2 section out of this either. It's just maybe we can define this a little bit better to what is truthfulness? What does that actually mean?
Well, especially in the matrix, the only discipline in this is termination, right?
Yes.
Yeah.
I don't think you need a class 2 on truthfulness.
No.
If we're gonna try to get back to telling the truth, we got to say that's all we're gonna accept.
Off.
By the way, I just read the Legislative Council Digest on AB 2644, and it says that anytime a juvenile is in custodial custody, so that interview or interrogation doesn't matter. If he's under arrest or prevented from leaving, you can't use any rules like that, and you have 2 hours before, within a 2-hour period, you have to have notified the public defender, and you have to notify his parents, a guardian, or responsible relative, and you got to Mirandize.
Yeah.
So, no, they can't use the rules here with juveniles.
But you said custodial arrest. So what if they're not under custodial arrest and they're just detained?
What's the difference between those two?
Well,
yeah. Well, one's the detention is I'm trying to figure out if they're involved in the crime to where I would make an arrest. So it's definitely a lesser threshold, but arrest is where they're actually in custody and I will transport them to a custodial facility.
Gotcha.
Well, if you have reasonable cause to believe that the minor has committed a crime or violated an order or whatever, then you have to Mirandize them. So if they're detained and you're trying to determine name and address and what are you doing out here, etc., I don't think you have to give a Miranda then.
And what if a cop just instructs a potential witness not to leave? Like, hey, I need to get a statement from you. Don't leave, right? They're not technically being detained, are they?
No.
Well, but this is where the ruse can come into play, though. You can say, well, you're just a witness, just to see if they, their witness account actually implicates them in the crime. That's where subterfuge can kind of sneak its way in here. It's worse.
This particular section doesn't eliminate that.
Yeah, right. And that's if
that still is a potentiality.
Yeah. And that's, again, a dangerous game because, again, it's all about it's like, oh, you're not under arrest. I can even proactively say to the juvenile, hey, you're not under arrest. I'm just talking to you. But my intention behind that is to use a ruse to get them to implicate themselves in that psychological tactic, if you will.
To lessen their guard too.
Yeah.
To disarm them psychologically. Yeah.
I think this came up, right, because of the last line that says, except when necessary under the performance of official duties. And then it almost feels like we have to say something like, considering also AB, whatever, and that law as it pertains. I don't know if you name those specific, assembly bills or anything like that, but it just feels like we have to kind of name that a little bit like, yeah, that's cool, except if it's a juvenile.
Law enforcement officers, this bill prohibits law enforcement officers from employing threats, physical harm, deception, or psychological manipulative interrogation tactics. That's the rules thing. That's what you're describing, Brian.
That's right.
As specified during a custodial interrogation.
Yeah.
So out on the street, all that's legal. and of a person 17 years or younger.
Yep.
So it's permissible. Hey, hold up! I just want to talk to you about your. I saw you play baseball last year. You
So the
know,
key word
what
there is
college
the
you going to?
custodial.
You know, you can do all that.
So that custodial piece, that's the key word that basically
Yeah.
determines once they're actually under arrest, right?
Right.
That's what custodial means, and interrogation, which is a Miranda category. So just an interview is not interrogation. I'm just interviewing them, and they're
I'm
not
just talking to him.
Let's say there's like a big melee of juveniles fighting at a mall, and you're like doing crowd control. You're trying to figure out, okay, who was involved, who's not, but you don't want anybody to leave at that moment, right? That's not custodial. I'm sorry, what's that term again?
Custodial interrogation.
Custodial interrogation, right? Or they're
No,
not
because
arrested.
you know, asking a police officer asking somebody to stay here is just that, asking.
Yeah, because we're
You
sorting.
don't have to stay. You don't. You could say, "No, no, I'm not staying anywhere. I don't want to talk to you," and walk away.
Yeah, but the example of juveniles fighting, the officer is there to discover the truth. Like who are the dominant or primary aggressors there? That may require just a mere detention of the juveniles and interviewing them to see who is most responsible. We don't want to make a mass arrest type situation where everyone's under arrest. No, we want to find out who's most. The problem with that is that if I'm going to say, well, they're not under arrest and I'm not interrogating them, I can do this. I can say to the juvenile, hey, your friend over there said that you were fighting, and I'm just using a ruse to get them to confess to me. That's where it becomes a problem. I mean, before this, I mean, you can argue it's not even a violation of this bill, this law, because they're not under arrest and I'm just using a ruse, and they fell for it. Yeah. This tactic is actually taught by California Post. It's in Learning Domain 15, where they call it subterfuge, which is, again, it's a euphemism for a lie. But yeah, they actually teach that it's absolutely legal to do this, almost encouraged in a way.
Start trying to use a ruse at home. I don't think that's going to go too well, though. All right.
Be careful.
I guess it goes back to the original question of going back to truthfulness. Like, do we need to like refer or mention or have language that just refers to this piece of legislation as it pertains to juveniles?
Certainly.
I think that was the initial comment that got flagged from the beginning.
Yeah, I have no problem putting that in there. I mean, if we're going to use the law as is, then I would have to put in there custodial interrogation. But remember that our policies can be more restrictive than what the law says. So that's a consideration for us also, if we do want to draw the line and say, even during a lawful detention. So. But I'll take a stab at that. I'll start with the citing the law and talking more about that. But do we want to also discuss just the intentional act versus not of being truthful, if there is such a thing? I mean, I think this might turn into a philosophical argument also.
Did you ask that question again? I was moving about. I didn't hear it.
Separating ourselves from the juvenile discussion, which I will put in there. Do we want to have a discussion about how we can develop this more on really the definition of truthfulness? Because here it just says you need to be truthful, but what is real truthfulness? Is it anything that, I mean, well, again, we can get pretty deep here into the weeds of what being truthful actually means, but I think we also want to possibly carve out the, mistake of facts, assuming that those mistake of facts are not intentional to where, you know, you're gaining, there's some benefit from it. I don't know. I probably need to do some more research on this.
For our edification, the Welfare and Institution Code section is 625.7, and it's pretty descriptive. 625.7 of the W-9 code in regards to holding and custodial interrogations on juveniles.
But we're putting a pin in the juvenile aspect of it, and now just relating this to officer truthfulness, say in an interrogation.
Yeah, I kind
Where
of
are we?
Yeah.
It doesn't even have to be interrogation. I mean, it can just be truthful in general. Just, you know, I'll give you.
I mean, so in all instances, I don't know how you define truthfulness except to say that if I look at this honesty, veracity, sincerity, to me, those are wiggle words. I think there's isn't there a universal understanding of truthfulness? Are you saying there might be shades of it?
Well, it's not so much that. I would say, yes, we all have a universal understanding, but let's just say a mistake of facts. Like, let's say that I showed up 5 minutes late to work today and the chief says, "Hey, you're late to work." And I say, "No, I wasn't." And then my watch, sure enough, shows that it's 5 minutes fast or right on time in my view. Is that truthfulness? And
Yeah, you're being truthful.
well,
if you look, if using your scenario, if you're looking at your watch and it's wrong, and you're saying that, yeah, I'm on time, you know, in order to be deceptive, there's got to be an intent to be deceptive.
What if I change
know the difference? If you don't know the difference, if you report something that's wrong, but you didn't know it was wrong, you don't know the difference between what the truth is and what is not the truth. So you think you're reporting the truth. That is truthfulness. When you discover later that, you know, you were wrong, absolutely off base, and you can say, I was wrong because of these extenuating circumstances, then you didn't intentionally lie to anybody.
So it's a lack of deceit.
Yeah. So I don't think we have to, I think the more words we put in here, the more trouble we're going to get in. Yeah, I think truthfulness has to be just what it is. Are you telling the truth, the whole truth, and nothing but the truth to the best of your knowledge? And if you say, yes, I am, okay, we're going to take that as a fact. If we find out that you knew better or should have known better and was dishonest, that's a lack of veracity there.
Yeah, because this is not a reasonable person thing. I think if a reasonable person would have thought it was truthful, no, we're not trying to give that kind of grace here. When is this challenge? Give us a scenario or example. And what are you this week, captain or lieutenant?
I'm actually acting deputy chief for Chief Mendoza, who's on vacation. So change again.
Oh man, I've been getting it wrong this whole time.
Brian is fine too. Deacon,
you gotta ask him every week.
So much easier. Brian.
So Brian is better.
I like that better.
Okay, in this situation, you're just Brian.
Yes.
So give us an example of when this may occur or has come up.
Sure. An easy one would be vehicle collision. So an officer, let's say, comes out and sees, they start their shift, they see that there's damage to a police vehicle and they report it to their supervisor. So then the question is, was this damage known by the one who previously drove the vehicle and did they report it? So then the truthfulness argument comes in of whether they should have reasonably known that this damage exists. And I'm talking about, let's say, a moderate sized dent in the rear panel of the vehicle, not like the whole car is totaled. So there's a truthfulness allegation. It's like you were driving this vehicle, you should have reasonably known, or the question is, should you have known that this damage exists? And the officer says no. Then it becomes an argument over truthfulness, whether one they should reasonably known. And then, that happens quite often.
Well, again, there's an opportunity to test the allegation of whether you're being untruthful or not.
Yeah, I would look at the damage and see what kind of damage. If it's, you know, if he just scraped the side of a fence and didn't know it, I mean, while he was driving, that happens. I mean, truck drivers and buses, they hit stuff all the time and don't even feel it. So, but if this guy comes in and his tail light is broken out and he says, hey, I didn't know it, but you should have known it. You should have checked the car before. That's truthfulness. Even if he says, look, I didn't lie about anything. No, you was derelict in examining your car before you turned the keys in. And so you were lacking of being truthful in that you did not inspect the car. I guess when you sign a car in, you check off that you did inspect the car.
But isn't that a different offense, Reggie, okay, he wasn't being untruthful, he was derelict. He didn't promptly report something.
No, this is how I saw the procedure happening. You turn your car in, you got to inspect your vehicle. Stop me when I'm different from what you do in Oakland, Brian. You have to turn your car in and you go, and for the record, you sign your name or check out, I turned in car 1, 2, 3, 4, no damage.
Okay.
Right? So then the next guy gets the car, comes out, and the headlight is busted out. So either it was busted out from the time you got out the car and turned it in, or you never checked the car. So there's a truthfulness issue.
Okay, so if that's process and procedure, the prerequisite before you can turn in your car, you walk around it like when you pick up a rental car and see what kind of dents are in the car, and you report those.
And correct. Stop me, Brian, if this is wrong now. If and you do that with cars, you do that with radios, right? You do that with all of your equipment.
We don't have a turn-in inspection. It's you check out inspection.
So you can turn the car in any kind of way you want.
Well, I mean, but remember, we talked about this section when we first started this ad hoc, was there's a presumption. So it's always the presumed last person who would take the blame for the damage. So it would be in their best interest to do an inspection before they turn it in.
We need to change that policy then. If this is such a big thing, if this is a roadblock to truthfulness, to understanding what truthfulness is, then they need to check their equipment. If that's the best example you can come up with. Otherwise, I saw truthfulness is I saw him run out of the bank and he shot off 5 rounds, and the guy you said did it wasn't even in the state. You're lying on a police report. That's what I'm saying truthfulness is.
Yeah, that's an extreme example, but the collision issue, and then I'll just take a step back. Let me create a different situation. It's not the damage that's in question, is who caused the damage. So was it an officer backing into something, or while they're out of the car and inside one's home taking a police report, someone hit their car and drove off? So we're now split. It was like, did the officer cause it, or did someone, is the officer a victim of a hit and run?
I'm taking the officer's word for it. If he says that we can't have a system where that a person who's asking a question of a police officer can avoid having to assume that they have taken an oath of office and they are telling the truth. We're supposed to be hiring highly ethical people who are truth tellers. Our issue for OPD has not been that. The issue for OPD has been the lies on police report that later on were overthrown by video or audio evidence. That's where the problem is. That's where the people who have a concern about the veracity of the police department, they say, because you've been caught several times writing something one way, and after they looked at the video evidence, that's not it. That's why we got video cameras now. We only got them not because we didn't have any place else to spend the money. We got them because OPD was caught incessantly lying on police reports.
Yeah. So all your points are spot on. So here's the other side of this too. So if you're all familiar with Task 45, it talks about the consistency of discipline. As a commander, let's say that I just don't like someone. It's so easy for me to put a truthfulness case on them. And then we're now arguing over whether it was objectively right to discipline them or terminate them really for truthfulness. And that's what we want to avoid also. I want to give commander supervisors a clear path of, this is a clear truthfulness issue and you need to investigate it, versus, you ask the officer, did you follow policy? And they say, yes, I did, but they actually didn't. But in their mind, they thought they did. A nefarious supervisor commander can just say, oh, you're being untruthful. And that just adds a lot of stress when one is now being accused for truthfulness when in their mind it was just good faith.
Now,
So
is that the exception of the norm? If we got 100 cases around truthfulness, is that 1 or 2 times, or is that 50 times?
it's more likely than not that one would not be sustained for truthfulness, like more exonerated. But it just shows that we do cast a wide net because we do investigate. Yes, we do get truthfulness terminations, but the exonerations and not sustains far exceed that, or unfounded far exceed that.
Well, I think we may be making a mountain out of a molehill. The issue is not for OPD. The issue is not the commander who is harassing some officer around making up some weak case and labeling it truthfulness. That's the exception. The overwhelming majority of the cases, overwhelmingly, for decades, is writing something in a police report that is not the truth. That has been the problem.
Yeah.
Or you interviewing somebody after a shotgun blast with less lethal ammunition came out and hit a journalist in the side of the head, and you interview 25 officers and everybody says they didn't hear nothing and they didn't see nothing on Broadway. Where it's like a valley, an echo. How could you not hear that? That's what we're talking about. That's the truthfulness. I don't want to get major into minor on truthfulness. Our issue the dragon we're trying to slay is police reporting veracity. That's what we're trying to get at.
Yeah.
At least in my mind, that's what we kind of get at. And if I stand alone on that, then fine.
Well, I think I'm aligned with you in so far as there's a universal understanding about truthfulness, and there's an opportunity to challenge any allegation of untruthfulness. So without trying to provide any shades of truthfulness or mitigating anything around this particular provision, I honestly would leave it as it is.
Yeah, because we start dicing this thing up, and you're just giving someone a get out of jail free card.
Yeah.
Yeah, and that's fine. I'll add the juvenile stuff in here, and then we can see where we go from there. It's fine. Okay, the last one, which you probably don't have time for because this is a whole section in itself, is use of force, level 1 through 4. This will be a heavy discussion.
So what are we ending now or are we skipping this?
Well, we have a lot of sections to talk about, but over the past few weeks, I think we wanted to focus on the heavy ones, just be the most common ones, and that's where we're at. So we boiled it down to 4. So assuming we fix the custody of prisoners, truthfulness, etc., then this would be the last of the heavy, and then we can continue on from there.
Okay.
And can you tell me a little bit what's the level 1 through 4? There's just like different levels, different examples, or there's like a section for each level. How does that all break down?
Sure, and I have it all written here. Basically, all force that we use has a particular level to it. Level 1 being the most severe. So any use of force resulting in death, for example, that would be a level 1. And there's a whole process that goes with that type of force. A level 2 would be, for example, if I use force against one who is handcuffed, that would be a level 2. If there was a canine bite on a person, that would be a level 2. Impact weapon like a baton to someone. Level 3 would be use of mace, use of a taser device on them. That would be a level 3, and the level 4 would be physical prowess, pointing my firearm at someone, etc. So, and there's much more to that, but those are the general levels. So when someone says, for example, the officer used unreasonable force on me, it doesn't matter which level, we would investigate it as a level use of force, level 1 through 4. And it's very vague because it just says the use of force shall be restricted to circumstances specified in department law, policies and law. And as you see here, it carries a pretty heavy weight. And what we're saying is so there's 2 ways of looking at this is, let's say that I use physical prowess against someone. I twist their arm to overcome the resistance to handcuff them. If the department says that I violated this section, it almost assumes that I used excessive force, when similar to custody of prisoners, it's like, well, we're not saying excessive force. We're just saying that there's a better way for you to do that. But there's only one category here, which is a level class 1 offense. So that's where this conversation's being steered towards.
So I'm sorry. So, but then depending on whether it ends up landing, determine whether it ends up being 1 through 4, that has implications on where it lands on the matrix, or the matrix just has one section for use of force. How does the corresponding matrix look?
Yep, it's right here. So it is just a class 1, and the first offense is counseling and termination, which is very wide. Suspension, 3 to termination, then termination. Now, there's aggravating and mitigating factors here. Obviously, if we determine that the force is excessive, termination will be a likely scenario. But let's say that there's a procedural lapse, or the force, like the intent there, it's a violation of policy, not so much the law. And yes, there is a difference. However, the subject didn't suffer any injury because of the force. There might be a mitigating factor there that might land them in this lower category. So it depends. But yeah, it's quite complicated because level 1s, like, can I just do let's, if I shoot someone, can that be a procedural error, or is that more excessive force category versus level 4 where you should have use more verbal persuasion before I went hands-on and twisted their arm a little bit to put handcuffs on. But as you see here, it's all in the same category.
Would this be one of those categories that you would consider having different levels, or having a class 2?
Yeah, I would. And remember that our use of force policy, which was written in collaboration with the commission, has a lot of technical violations. And one example of that is I pull my firearm at someone, and in that policy it says when reasonable to do so, and if appropriate, I tell the person why I pointed that firearm at them. If that person claims that I use excessive force and I'm being investigated for this very section, one can argue, well, you violated K3, you violated the policy because you didn't tell the person why you pointed your firearm. And so this is where it's like, well, is that what this section is really intended for? But yeah. As you can imagine, we get a lot of these allegations because anytime we use force against someone, usually there's, disagreement with that. So we levy a lot of these complaints, and that's why it's on the top of the list where we get most complaints, top 3 easily with this section. They result in a lot of exonerations and unfounded or not sustained because they did things according to procedure, but maybe there's room for room here.
Which kind of leads me to that class 2, right? Because maybe if there's only a class 1, they end up getting exonerated. But if there was a class 2, then we could determine they should have just still done better.
Yeah. Right. I think
would these different classifications, level 1 through 4, naturally be divvied up, like 1s and 2s are a class 1 and 3s and 4s, or that's very nuanced too? That could be like, there could be 4 levels within each classification.
The reclassification, well, I don't know if when we began this conversation, because I know this one was highlighted, whether we do want to talk about reclassifying force. I think that's definitely a broader discussion than what we're talking about here. Possibly, where let's say there's a level 1 use of force where by default it would automatically be assumed to be a class 1 allegation versus the lesser forms of force. The challenge with that is that officers are more likely to use a level 4 use of force than a level 1, 2, or 3. And if now knowing that it's just a class 2, it can be like, well, there's minimal accountability associated with that. So that's the dangers of doing that.
We'd hate to see an uptick of class 2 use of force violations because folks were like, well, it's going to be a slap in the wrist. It's not a level 1 termination anymore. So we can do this now, right? And then that kind of just spikes a little bit. That would be an unintended consequence that we really would want to avoid.
Yeah.
Okay. I mean, I do think these initial discussions around use of force are helpful as we attempt to dig deep into it, but no doubt we're definitely going to need some more time, maybe even a full meeting to cover the actual use of force itself, if we're going to tease out. Are there any potential suggestions or things that you may be able to pitch or draft to us for us to think about for next time around use of force?
Certainly.
Not just starting from scratch, but we could kind of see where you're going from there and then either agree or disagree. But at least it gives us a starting point in terms of like how we could start peeling back a little bit of the layers of this onion.
Yeah, certainly.
Cool. Sounds good. Well, let's do it. What time is it? All right, we're about 15 minutes out till 8 o'clock. I think this sounds like a good place. I think, is there any other just thoughts around this that we would all want to think about or digest before we come back? Or is there anything that you would recommend, Brian, for us to maybe look into further, or kind of just, is there any research or anything that we can do to kind of like better prepare for this? Because it does feel like this is a little nuanced and layered, or we just kind of take your direction on kind of some of your ideas of how we could kind of tease this out a little bit.
Well, I know we're gonna be away from each other for about 2 weeks. So I will get this done. I'll send it out so you can digest it in the next 2 weeks, and then I'll probably resend it just leading up to our January meeting, just so it's fresh. But I would say putting eyes on it early and just sit with it and see if anything pops in your mind.
Always a good idea.
Excellent. So we will, the next 2 Wednesdays are Christmas Day and New Year's Day. And we will reconvene January 8th.
Hey, happy
Is that
holidays.
correct?
Right.
Yep.
You got it.
Happy holidays, everyone.
Happy holidays.
Happy holidays. Bye-bye.
And
Thanks,
congratulations to the
everybody.
new
Safe.
author. To the new author, congratulations.
Thank you. Thank you very much. I appreciate it.
There she goes. You better invite us to the book signing.
Oh,
Oh,
yeah.
you know that. You know that.
Got to get my copy. Can we pre-order? Where do we pre-order at?
We're actually going to do a pre-order event, I think, at EOYDC. So I'll let you know. We'll get the date together. It'll be closer to the end of the month in January.
Will you sign my copy?
Of course.
Yes.
You don't even need to ask.
That's exciting.
Thank you. Thank you. And I done ran everybody off the call now. Mr. Chair, you're doing an amazing job.
Yes, he is.
Well, you know
And
what they
thank
say,
you.
Make it.
Thank you, Deputy Chief Hubbard. I hope we could just keep that title because it works. Looks good on you.
It has a nice ring to it, doesn't it?
Yes, it does.
Yeah, I can't, continue to express how much I appreciate you all, Brian, acting captain, acting deputy chief, wordsmith and extraordinaire. I just really appreciate you, and I hope you find some time to get some rest, eat some good warm food and some hot tea, and spend some good time with your family over these holidays. We know that the job is a tough demand, and you can't always
Yes.
get that, but anywhere you can squeeze that in, please do so. Per our orders here per these ad hoc orders, man, you need to get some rest, brother.
Right.
Next couple of weeks.
Got it.
That's right. So you can come back and continue all this progressive advice
Sure.
and counsel to us.
Of course. All right.
All right. And you could take that same advice, Mr. Chair.
Absolutely. Says the person that's busiest than ever, even in retirement.
Hey, now, what would you expect?
Well, and that's why we do what we do for the city, and the city is lucky to have us here in this commitment. And yeah, we'll get. Hey, it's okay to pat ourselves on the back sometimes,
That's exactly correct.
And so with that, we will bring this meeting to a close and call it a break for 2 weeks and reconvene in 2025.
Good night.
Hey, now. All right, everybody be safe.
Thank you. Take care.
care.
Bye-bye.